Imagine a company proudly announcing that its annual general meeting was conducted successfully. Shareholders voted, directors were reappointed, auditors confirmed, financial statements adopted. And suddenly, the Registrar of Companies discovers that the company never filed the statutory report of the AGM with ROC within the prescribed legal timeline. Overnight, what appeared to be a routine compliance event transforms into a governance failure, exposing the company and every responsible officer to penalties, secretarial audit observations, regulatory scrutiny, and future litigation risks. In modern corporate governance, even after conducting a legally valid AGM, the compliance journey is still incomplete until Section 121 reporting obligations are properly fulfilled. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Today, we are entering one of the most underestimated yet practically important compliance provisions under the Companies Act 2013, Section 121. Many professionals focus heavily on conducting annual general meetings properly, preparing notices correctly, ensuring quorum, passing resolutions, and completing voting formalities. But in actual secretarial practice, one silent post meeting compliance often becomes the reason for ROC notices, adjudication proceedings, and qualification in secretarial audit reports. That provision is Section 121, dealing with the report on annual general meeting. Section 121 appears technically small when compared with provisions relating to prospectus, mergers, oppression, mismanagement, or capital raising. However, experienced company secretaries and compliance professionals understand that governance failures are often identified not through large transactions, but through neglected procedural filings. The legislative philosophy behind Section 121 is extremely important. The Companies Act 2013 moved Indian corporate governance from mere event-based compliance to evidence-based governance accountability. Earlier, companies could claim that meetings were conducted properly without any structured statutory reporting mechanism proving that AGM procedures complied with the law. Section 121 creates an official governance trail. The provision ensures that companies cannot merely conduct annual general meetings privately and internally. They must officially report compliance before the Registrar of Companies through a prescribed filing mechanism. This creates transparency. This creates accountability. This creates documentary evidence. This also assists regulators in monitoring whether shareholder democracy is functioning properly. The historical governance background is equally interesting. Before the Companies Act 2013, regulators increasingly observed situations where AGMs were allegedly held without proper participation, without valid procedures, without fair voting systems, or without proper disclosures. In several cases, minority shareholders challenged AGM legitimacy. The legislature therefore introduced a formal reporting framework through Section 121, requiring certain companies to file a report confirming AGM conduct in accordance with statutory provisions. Now let us understand the exact legal structure of Section 121 in simplified professional language. Section 121 states that every listed public company shall prepare a report on each annual general meeting, including confirmation that the meeting was convened, held, and conducted in accordance with the provisions of the Companies Act and rules made thereunder. This report must be filed with the registrar within 30 days of the conclusion of the AGM. Immediately, one important practical concept becomes visible. Section 121 is not applicable to every company. This is one of the biggest exam traps and practical mistakes. The obligation specifically applies to listed public companies. Private companies are generally outside the mandatory applicability unless some other special regulatory expectation arises. Unlisted public companies are also generally not covered directly under mandatory Section 121 filing obligations. Listed companies, however, fall directly within the compliance framework because public investor protection and governance transparency standards are much higher. This reflects the broader governance philosophy applicable to listed entities under securities regulation. The law recognizes that listed companies manage public money, investor confidence, and market integrity. Therefore, the regulator expects enhanced documentation of shareholder meetings. Now, let us understand the important legal words inside the provision. The expression report on AGM does not merely mean minutes of meeting. This is another major practical misunderstanding. Minutes are separate records maintained under Section 118. The AGM report under Section 121 is an independent compliance document. The report acts like a statutory governance confirmation document submitted to ROC. The expression convened relates to lawful calling of the meeting. The expression held relates to actual conduct of the meeting. The expression conducted relates to procedural compliance during the meeting process. This means the report indirectly certifies compliance relating to notice, quorum, chairman proceedings, voting systems, attendance, auditor participation, shareholder rights, and statutory procedures. Now let us connect Section 121 with the relevant rules. The important rules are contained under the Companies Management and Administration Rules 2014. Rule 31 specifically deals with the report on annual general meeting. This rule becomes extremely important during secretarial audit and compliance verification. The rule prescribes the contents of the report and the filing mechanism. The prescribed e-form for filing is Form MGT-15. This is one of the most important practical compliance areas. Students often confuse MGT-14 and MGT-15. MGT-14 relates primarily to filing of resolutions and agreements under Section 117. MGT-15 specifically relates to filing report on AGM under Section 121. In actual practice, ROC filing errors frequently arise because inexperienced staff upload incorrect forms or incorrectly classify the filing purpose. Now let us understand what details are generally included in the AGM report. The report contains the date, time, and venue of AGM. It includes confirmation regarding chairman of the meeting. It records number of members attending. It specifies whether quorum was present. It confirms compliance regarding notice. It includes business transacted. It confirms voting compliance. It records adjournment details, if any. It may contain observations regarding poll, e-voting, or scrutiny procedures. It also contains confirmation that the meeting was conducted as per Companies Act provisions. This effectively converts the AGM into a documented governance event review. Now think practically from an investor protection perspective. Suppose minority shareholders later allege that voting manipulation occurred during AGM. Suppose investors allege improper conduct. Suppose regulators investigate governance irregularities. The AGM report becomes a critical evidentiary document. That is why Section 121 has immense litigation relevance. Now let us discuss the timeline carefully because timeline mistakes are extremely common. The report must be filed within 30 days from the conclusion of the AGM, not from preparation of minutes, not from signing of minutes, not from board approval, not from uploading of financial statements. The clock starts from AGM conclusion date. This distinction becomes critically important during compliance audits. Now consider a practical example. Suppose AGM was held on 30th September. The filing should normally be completed within 30 days from that date. Delay beyond the prescribed period may attract penalty consequences. Now let us understand penalties. If the company fails to file the report within prescribed timeline, the company becomes liable to penalty. Every officer in default may also face separate penalty exposure. This demonstrates the governance philosophy of officer accountability under the Companies Act 2013. Corporate compliance failures are no longer viewed merely as company defaults. Responsible officers, including directors, company secretaries, and compliance officials, may face consequences. Now let us examine the role of the company secretary. In actual corporate governance practice, Section 121 compliance is heavily dependent upon the company secretary. The company secretary usually coordinates AGM compliance documentation, attendance records, scrutinizer coordination, e-voting reconciliation, and ROC filing procedures. Failure to maintain proper coordination may result in defective AGM reporting. Secretarial auditors frequently examine whether MGT-15 was properly filed. Non-filing may appear as qualification or adverse observation in secretarial audit report. This can impact governance ratings and investor confidence. Now let us connect Section 121 with Section 96. Section 96 mandates annual general meetings. Section 121 creates reporting accountability after AGM completion. Thus, Section 96 creates the obligation to hold AGM, while Section 121 creates obligation to report governance compliance regarding AGM conduct. Similarly, Section 118 relating to minutes also becomes interconnected because AGM reporting often relies upon minutes verification. Section 108 relating to e-voting also becomes relevant for listed companies. SEBILODR provisions regarding shareholder meetings, voting disclosures, and scrutinizers also interact practically with AGM reporting compliance. Now let us discuss listed company governance realities. Listed entities usually conduct AGMs through hybrid systems, physical mode, video conferencing systems, or other permitted mechanisms, depending upon regulatory relaxations and MCA circulars. The AGM report therefore becomes evidence that procedural safeguards were properly followed. This includes shareholder participation opportunities. This includes electronic voting systems. This includes transparency in chairman proceedings. This includes fair conduct standards. This includes scrutinizer reporting. Now let us discuss an important hidden practical concept. Many professionals incorrectly assume that if AGM itself was validly conducted, delayed filing of MGT-15 is merely technical. This assumption can become dangerous. Repeated procedural non-compliance creates governance risk profiling before regulators. During due diligence exercises for IPO, mergers, acquisitions, or investor funding rounds, recurring filing defaults may be identified. Investors increasingly examine compliance culture. A company regularly ignoring procedural compliance may be viewed as weak in governance discipline. Now let us analyze a practical case study style illustration. Imagine a listed company conducts AGM successfully. Financial statements are adopted, dividend declared, directors reappointed. Everything appears compliant. However, due to internal negligence, MGT-15 filing is forgotten. 3 years later, during IPO due diligence for a subsidiary restructuring transaction, compliance advisors discover the historical default. Now the company faces adjudication exposure, additional compliance cost, and governance embarrassment. This is how small procedural failures become future transaction risks. Now let us discuss common ROC rejection reasons. Incorrect CIN details, incorrect AGM date, mismatch between AGM notice and filed report, improper DSC authentication, incorrect designation of signing authority, failure to attach required supporting documents, defective certification, incorrect mention of quorum details, discrepancies between voting records and AGM report. These are extremely common practical filing failures. Now let us discuss board level procedural aspects. Although Section 121 itself does not expressly mandate a separate board resolution for every filing detail, good governance practice generally involves proper authorization for ROC filings and compliance actions. Companies usually authorize company secretary or compliance officer to complete statutory filings. In well-governed companies, AGM compliance calendars are prepared in advance. Professional governance systems ensure simultaneous tracking of AOC 4, MGT 7, MGT 14 wherever applicable, and MGT 15. This integrated approach reduces compliance risk. Now let us discuss notice requirements. Because AGM reporting indirectly depends upon notice validity. Improper AGM notice itself may create governance defects. Notice under Section 101 generally requires clear 21 days notice unless shorter notice conditions are validly satisfied. The AGM report indirectly confirms compliance regarding meeting validity. Therefore, defects in notice may ultimately affect AGM reporting credibility. Similarly, explanatory statements under Section 102 become relevant where special business is transacted. Listed companies must ensure proper disclosures. Failure to disclose material facts may create shareholder litigation risk. Now let us discuss voting aspects. Listed companies frequently use remote e-voting systems. Scrutinizer reports become crucial. The AGM report should align with actual voting records. Mismatch between scrutinizer report and AGM reporting may create suspicion during regulatory review. Now consider another practical governance risk. Suppose activist shareholders challenge chairman conduct during AGM. Suppose allegations arise regarding suppression of shareholder questions. Suppose e-voting technical failures occur. Suppose meeting recordings contradict official statements. In such situations, the AGM report may become central evidence in governance disputes. That is why drafting quality matters enormously. Now let us examine applicability on different classes of companies. Private companies generally do not fall directly within Section 121 mandatory reporting requirements because the provision specifically targets listed public companies. One-person companies are outside AGM framework itself because OPCs are exempt from holding AGM requirements in normal circumstances. Dormant companies may have reduced operational activity, but if listed status does not exist, Section 121 normally remains inapplicable. Listed public companies remain the primary focus area. This selective applicability reflects risk-based governance regulation. Now let us discuss interaction with SEBILODR. Listed companies already face extensive shareholder meeting disclosure obligations under SEBI regulations. Voting results disclosure requirements. Scrutinizer report disclosures. Website publication obligations. Stock exchange intimations. Corporate governance reporting. Section 121 complements these obligations by creating statutory ROC-level reporting accountability. Thus, companies must maintain consistency across ROC filings, stock exchange disclosures, and shareholder communications. Any inconsistency may trigger scrutiny. Now let us discuss due diligence perspectives. During mergers, acquisitions, IPOs, private equity investments, and legal audits, professionals examine historical AGM compliance. Absence of MGT-15 filings, where applicable, may indicate governance negligence. Buyers and investors increasingly insist upon clean secretarial records. Therefore, Section 121 compliance has commercial transaction significance beyond procedural filing. Now let us analyze professional responsibility perspectives. Advocates advise on litigation exposure. Company secretaries manage procedural compliance. Chartered accountants examine governance implications during audit processes. Cost accountants may analyze internal governance systems where relevant. All professionals interact with governance compliance ecosystems created under the Companies Act. Now let us discuss hidden exam concepts. Students frequently confuse AGM report with annual return. These are different concepts. Annual return under Section 92 provides company information and governance disclosures. AGM report under Section 121 specifically certifies conduct of AGM. Similarly, students sometimes confuse minutes with AGM report. Again, completely different. Minutes are internal statutory records. AGM report is external regulatory filing. Now let us discuss drafting precautions. Never mechanically copy previous year filings without verification. Ensure attendance figures are accurate. Ensure voting data aligns with scrutinizer records. Ensure venue details are correct. Ensure signing authority is valid. Ensure digital signatures remain active. Ensure filing timelines are tracked through compliance software or calendars. These small precautions prevent future governance complications. Now consider another real corporate situation. Suppose a listed company conducts AGM through video conferencing pursuant to MCA circular relaxations. If participation records, attendance logs, or e-voting reconciliation are weak, preparation of accurate AGM report becomes difficult. This demonstrates why governance documentation systems are essential. Modern compliance is evidence-driven. If compliance cannot be demonstrated, regulators may assume compliance failure. Now let us discuss investor psychology. Investors may never directly read MGT-15 filings regularly, but institutional investors, governance analysts, and due diligence professionals often examine compliance culture deeply. Repeated procedural non-compliance damages governance credibility. Strong compliance discipline improves investor confidence. Now let us examine litigation risk analysis. Suppose shareholder disputes validity of director appointment approved in AGM. Suppose allegations arise regarding quorum defects. Suppose notice delivery challenges arise. The AGM report may become one of several critical documents examined by adjudicating authorities or tribunals. Therefore, Section 121 indirectly contributes to evidentiary governance architecture. Now let us connect this with Secretarial standards. Secretarial Standard on General Meetings, issued by the Institute of Company Secretaries of India, becomes extremely important. Listed companies are expected to align AGM procedures with applicable secretarial standards. The AGM report indirectly reflects procedural adherence. Secretarial auditors frequently cross-verify these aspects. Now let us discuss consequences beyond statutory penalties. Non-compliance may lead to governance red flags, board credibility concerns, investor dissatisfaction, adverse audit observations, difficulty during fundraising, regulatory correspondence, higher scrutiny during inspections. Thus, the impact extends beyond monetary penalty. Now, let us analyze why Section 121 matters in actual corporate governance. Corporate governance is not merely about large strategic decisions. Governance also means procedural integrity, transparent shareholder democracy, documented accountability, regulatory traceability, institutional discipline. Section 121 reinforces these values. It ensures that shareholder meetings are not treated casually. It converts AGMs into accountable governance events capable of regulatory verification. That is the true importance of this provision. For law students, this provision teaches the philosophy of compliance documentation. For company secretaries, it represents one of the most practical recurring ROC filing obligations. For directors, it demonstrates accountability exposure. For investors, it strengthens governance confidence. For compliance professionals, it highlights the importance of procedural precision. For litigators, it provides evidentiary governance material. For regulators, it creates monitoring transparency. And for modern corporate India, Section 121 represents a small but extremely powerful governance safeguard, proving that compliance does not end when the meeting concludes. Compliance ends only when lawful reporting, documentation, and accountability are fully completed. If you like this video, kindly like, subscribe, and hit the bell icon for latest notifications from Corporate and Securities Law Compass. Like, share, comment, subscribe.